Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our two-weekly community conference call for immigration questions. All conversations are subject to the disclaimers you heard when you were logging in. Let me just check and make sure that you can hear me. The date today is July 7th, 2022. One second.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you hear me all right?
Yes.
Thank you.
The
Okay.
conference is now in presentation mode.
Let's begin with the questions that I have marked as frequently asked questions first. So if you have any follow-up questions on the questions I talk about, feel free to raise your hand by pressing *5 on your telephone. If you have new questions, they'll have to wait till the end after I have answered all questions. Let's just make sure. One second. Let me move this. Okay. So first question, frequently asked question is experience and education requirements for a PERM labor certification based green card. First question, how often does it happen that an employment based green card gets rejected because the minimum job requirements were low? So rejected or delayed. And that's a very difficult question to answer. What are you trying to do when you are doing a PERM-based filing? What you're trying to do is, first of all, you are putting down your minimum requirements. The employer does. What are the minimum requirements for this job? There's a difference between labor certs for ordinary mortals and for college professors. For professors, we are allowed to choose the most highly qualified candidate. But for ordinary labor certifications in the commercial world, we have to select or consider anyone who's minimally qualified for the job. So therefore, the first requirement is that you've got to define your job minimally. Second requirement is you've got to advertise in many different places and show the government that despite your advertising, you were not able to find a U.S. worker qualified for the job. And this has to be done in an honest way. You can't make things up, you can't lie, you can't be dishonest. So how often does a green card like this get rejected because the requirements were low? It will get rejected not because the requirements were low, but because the requirements were so basic that there were many applications for it. So for example, if I say I require a bachelor's degree in information systems, and that's all my requirements are, of course I'm going to get plenty of qualified people. There are many people in this country who have that degree. But if on the other hand, I've got experience, bachelor's degree in information systems, computer science are equivalent with 5 years of experience. Experience must include work with non-SQL databases, Hadoop, containerization, all the state-of-the-art technologies. My chances are better because my job minimally requires knowing all that stuff. And if there are not going to be enough people, because people who have those kind of skills already have jobs. So therefore, this is a balance between honesty and best presentation. We are allowed to make the best presentation of our case, but we are not allowed to lie about things. So it's a very odd balance in some ways. Although our interest is in winning the case, our duty is to tell the truth. Okay. So how many times does a green card get rejected because the requirements were too low? The answer is it's not the green card that gets rejected, it's the recruitment failing. So you have to start all over again. Second question, what could be decent experience and education requirement for a job to successfully process an employment-based green card? Well, that's a very difficult question to answer. It depends upon the job. For example, if I were looking for a neurosurgeon, I think without experience, just advertising for a neurosurgeon would be enough. There are not enough people who are looking for this kind of job. Also, again, depending upon the skills and technologies. For example, we have a client they develop vision-based diagnostic systems. So their requirement, one of the requirements is that you must have taken graduate level courses or done graduate level thesis or have considerable experience. Of course, we have to quantify that in vision systems, all that is involved, vision sensors, how the input is processed, how the feedback works, some amount of machine learning, a lot of AI, and a lot of hardware experience or training. So it depends upon the job. I can't give that answer in isolation from other things. Question number 3. My current employer is filing my green card with minimum requirements of a bachelor's and 1 to 2 years of experience. First of all, there is no such thing as 1 to 2. When you say 1 to 2, it means 1. Okay, be very clear about that, because we are only allowed to ask for minimal, not desirable level of experience. Okay, then my current qualifications are a master's and 2 to 3 years of experience. So again, here the question is not so much what your qualifications are, but what does the job require? One point that I would give your employer is that, remember, if you are an India-born person, it could be 10 plus years before you get your green card. So the employer is allowed to project their mind 12 years in the future or 10 years in the future or 6 or 7 years in the future and say, you know what, this job only requires a bachelor's degree. Now let's say software developer, but senior software developer job, which is the next higher position, requires a master's degree with 1 year or 2 years or 3 years of experience. So you can always project your mind in the future and do a green card for a job that is different than your H-1B job. We do it all the time. We have to, because many of our clients are India-born people. They don't have a choice. They could be stuck in the process for a long time. Okay. Should you file and find a new job where green card can be filed? Well, that's definitely your call, but I've explained to you the issues. If anybody has a follow-up question on this, press *5 on your phone. Any follow-up questions on this? Press *5. No new questions. Okay, let me go on to the next frequently asked question. Let's see. I think I had a bunch of them this time. Maybe at least 4 or 5. Where did they all go? Oh, here's another one. This one says, continuing work or reverting to STEM OPT during H-1B change of status. So let me clarify a couple of things here. When you file your H-1B with a change of status requested from your OPT, which is student status, your DSO will suspend or, well, I don't know if they call it cancel, but basically your SEVIS number is put to sleep. The only time your DSO will reawaken that, and so that you can get back to your OPT, is when you show them that either the H-1B has been withdrawn or denied. That's been my experience. So check with your DSO what are the requirements to reawaken your SEVIS number after it has been put to sleep because of a change of status filing of H-1B. Of course, if H-1B is filed with consular processing, that's no problem. But if it is filed with change of status requested, you will have an issue. Okay, so keep that in mind. So the question is, if I change my employer while my H-1B change of status is filed, but not yet approved, then can I keep using my OPT and STEM? You can, but double check with your DSO what are the technical issues involved there. Okay, I don't see why not, because until the H-1B is approved and October 1st arrives, you are really on OPT, which was your continued status from before. Number 2, if my change of status is denied, can I keep using OPT and STEM? I just explained. Just go back to the DSO and say, please, I want to continue on my OPT and STEM. How often does it happen that H-1B change of status transfer and renewal get denied? All the time. All the time. What are the possible reasons? I could write a book on that. There are many, many reasons for that. One of the suggestions from this author is this portal does not allow to edit questions after 30 minutes. Can you please remove this time limit so that we don't need to do multiple posts? I have actually asked Monica to remove that restriction, so you can edit your questions anytime as long as it is before the thread closes. Monica wanted to know how much time should we put as a restriction. I said, you know what, just ask in the forums what everybody wants to do. Whatever they want, that's what we should do. So if you have any suggestions about removing this limit of changing your answer or your question within 30 minutes, you can let Monica know what your thoughts are. You can just email her at Monica, MOINICA, @immigration.com, and just say that you were talking with Rajiv about removing the edit limits of 30 minutes on the forums. I think we should do X number of hours, or just remove the limit altogether. I think it's okay to remove the limit altogether, but that's really I don't see any reason why that should be there at all. So just let Monica know your opinion. Okay, if you have any follow-up questions on the change of status and OPT, please press *5 on your phone. No new questions, only follow-up questions. *5. Okay, let's go on to the next frequently asked question. Like I said, here's another one. So this is an interesting question. It does come up all the time. For PERM, can I use my master's degree completed after I joined? The answer is, well, probably not for the same job for which you were hired. Remember, I gave the example that you can always do PERM for a future job. So let's say you got hired as a software developer, but the next job higher up is senior software developer, which you don't have yet, but will be given to you sometime in the future before or after you get the green card. So you can't use your master's degree that you obtained after you joined as a software developer, but you could certainly use it for the next higher job. Okay, I hope that makes sense. *5 if you have a follow-up question, *5. Okay, let's go on to the next. Oh, this is the end of the questions. Now I'm going to go into the other questions that were non-frequently asked questions. But I'm going to lock the conference now, so I don't want any more people to join. Let's just lock the conference.
The conference is now locked.
So what I'm going to try to do is that all the new questions also will try to answer them today. That's why I locked the conference, because otherwise, if people walk in at the last moment, it becomes difficult to keep track of the traffic and answer everybody's questions. Okay, so here is the first non-frequently asked question about a Freedom of Information Act request. And then they received a response which basically says we don't have anything on you. So you are trying to get an I-140 approval notice. So all it says is the notice says you can provide us with additional information. So try to give them additional information. I have never had this experience before, so I don't really know what best to advise you. My advice would be to just try to comply with providing additional information. You can even tell them exactly what you are looking for. Okay, so hopefully that should take care of it. Okay, I just locked the conference. I don't know what happened. Anyhow, so going back to this situation, you had shared your notarized copy, passport, visa, driver's license, I-140 receipt number. I think you've given them a lot of information. I really have no idea why they are giving you this. See if they have a FOIA officer that you can talk with, explain the problem, and see what they suggest. I have no first-hand experience with this problem. We've never had this issue come up before. *5 if you have a follow-up question on this. *5. Okay. Next question is similar job criteria, checklist of required documents, and change of location. So you worked at XYZ company, did your I-140 priority date 2017. Then you changed employers. And the employer is reluctant to start the green card process, giving weird reasoning. They can only start with 2 years priority date cutoff. That's nonsense. the way priority dates are moving, etc., etc. I'm thinking of going back to the same employer who sponsored my priority date and file my 485 when the dates become current. Okay. I understand the same job needs to exist. I see the same job title and matching responsibility, but there are some changes in the government, in the employer's business. The new jobs are with different department in the same company. Okay, so I really don't care which department the job is with, as long as the job requirements are same. Okay. Now, this is a decision that your lawyers have to make. I can't make a decision in the abstract. So it's like you can't ask a doctor to diagnose a patient without examining the patient. All I can tell you is that your lawyer should look at it. Department doesn't matter. So let's say, for example, again, software developer comes to mind, or database administrator. Let's say you were a DBA with the marketing department, and they had 9 servers that you were maintaining their databases on. And then there's a job that opened up in procurement. This is a totally different department in the same company. But because the company is the same, the job location is the same, the job title is same or similar, and the job description is the same, it shouldn't matter if you are working with a different department. Can I go to a higher designation job? My guess is not without redoing the PERM. Unless after 180 days of 485 filing I-140 approval, you cannot really change your job description substantially. Okay. Since I-485 filing is responsibility of employee, what documents are required from the company side? Well, they need to provide you a job offer letter that proves, but probably supplement J, which proves that they have a job for you. Can I file I-485 now? Well, that's complicated. We have this in our frequently asked questions. I've discussed this issue many times. The bottom line is that you can be called to show why did you leave the employer if you wanted to work for them on a permanent basis. Why are they holding the job open for you? Do they still have the ability to pay wages? These are all issues you should discuss with your lawyers. I cannot really tell you what your situation is. Change of location. Again, if your job location doesn't change, where you personally live shouldn't matter, because the PERM-based green card is tied to your job location. It is not tied to your home location. Okay. So of course, and you do understand that sometimes, let's say you do a green card through location A, but you are working at location B of the same employer, but after receiving the green card, you come back to A. Yeah, that's fine. That can also work. *5. If you have a follow-up question, press *5 on your phone. Okay. Let's go on to the next question. Oh, there is a question here. Area code 313. 313, where are you calling from?
Yeah, hi Rajiv. This is I'm from Michigan.
Yes, sir.
Michigan.
Go ahead.
Yeah. Actually, I posted this question. So the first point, I want to know, like, how much similar the job should be.
There is no quantitative measure. I can't tell you that the job should be 9.5% similar. There's no such thing. It should be the same job, basically, no substantial difference. This is not the same thing as same or similar for AC-21 portability. This is totally different. They should be the same job.
Okay. Because the job is like the same title. I mentioned there is some different department, but it's the same title.
Yeah, I can't. Hang on. Before we get into this highly hypothetical conversation, I cannot tell without looking at the jobs. Tell your lawyers to look at that and tell you whether this job will work for you.
Okay.
Okay. What else? Anything else?
Thank you.
You're welcome. Okay. Next question. Let's see. We did this. So this is a question about backup option during my max out date. My spouse is on H-1B with I-140 approved. So I'm maxing out October 28, 2022. PERM has been filed. Husband is on H-1B with I-140 approved. So if the I-140 doesn't get approved, so I can't extend my H-1B, we are thinking to file H-4 plus H-4 EAD with the start date of October 17th. Yeah, why not? That sounds all right. Can I legally stay in the United States after max out? Yes, you can. You just cannot work until you get your EAD. Will I be exhausting 6 years of H-1B visa? No, you will not be. Because once your period is maxed out, there's no more H-1B. You are staying because your H-4 was timely filed and pending. Will you be able to file for an extension after the I-140 is approved? Yes, you will be able to. The only thing is, if your H-4 is still pending, you might have to step outside, get an H-1 visa stamp and come back once your H-1 is approved. So that has a set of minor complications. How do you deal with the H-4, H-4 EAD? Would you have to refile? Probably yes, you would have to if you want to use it. But again, you really are not going to use it. So by stepping outside the United States, you should have abandoned both your H-4 as well as EAD. If you're going to use only your H-1, great, just let it go. And you'll get H-1 extension for 3 years if your I-140 is approved. So the only complication is stepping outside the United States for a visa stamping. And you can go to any country, don't have to go to India. So let's say we file for change of status effective October 17th and we get the I-140 approved. Will my employer be able to file an extension, or I'll be in H-4 status during that period? Yeah, you have to step outside the United States if the H-4 is not yet decided. Star 5, if you have a follow-up question, press star 5. All right, let's go on to the next question. Green card is approved. What is the next step from the USCIS? I-485 has been approved. Oh, I have to take that. I'll be right back. Just a moment. Okay, sorry about that. Back again. So my I-485 has been approved status for the past 20 days. I have not received my green card. I have an international trip coming up. You should make an appointment through InfoPass. INF as in Frank, O, info as in information. Do an appointment through InfoPass and get your passport stamped for travel. That's called an edit stamp, ADIT. That's as good as having a green card. So get your edit stamp. That should take care of it. Star 5 if you have a follow-up question. Star 5. Okay. Changing jobs during the green card process. This is the question number 7. Oops. Oh, what did I just do? I just went up a level. Sorry about that. Question number 7. 4, 5, 6. Here we go. 7. Changing job. My priority date is July 14th. I have an I-140 approved from employer A in EB2. Unfortunately, I switched my employment with employer B last year. Date is current, but I'm not with the old employer. Current employer has started green card process last year, but the PERM has not yet been filed. So the problem here is this. Again, I've dealt with this issue so many times in our frequently asked questions. Why would the old employer hold the job open for you? And why would you leave them if you had the intention to get a green card through them? Now, this issue they don't bring up quite frequently, but you have to be prepared to answer it. Okay, so you should talk with your lawyers and also see some of our frequently asked questions and make sure that you understand what the issues are. Theoretically possible, but practically be careful. You can certainly do this. Can my current employer B file 485 with my previous employer A's approved I-140? No, they cannot. The only time you can do that is if you have an I-140 like a EB1A or NIW, because it doesn't depend upon a job. Can I really do this as even EAD will be not? No, you cannot do it. Should I wait till my new PERM approved and port priority date? I think that's the best thing. The dates might get retrogressed. Well, unless you want to join the old employer, this is not a question I can answer hypothetically. You should talk with your lawyers, listen to our frequently asked questions. I've dealt with this issue multiple times. What is the best strategy? It's so difficult to say this. If you genuinely want to join the old employer, you can file through them. Otherwise, you shouldn't. That's my opinion. Press star 5 if you have a follow-up question. Press star 5. Okay, I'm going to go back to the next question, number 8. PERM and H-1B amendment for location change, employment verification letter, RFE, denial of employment of green card based on previous employment and experience. So question is, during PERM and H-1B change of status, does relocation create any problem? If it is your address, the problem is relatively small. For H-1B, it can be huge. If you are within about 50 miles of the previous location, it's not a big deal. But any larger relocations can cause a collapse of your H-1B. It would have to be amended. For PERM, it's usually the employer's headquarters that matters. But again, it depends upon how your PERM is drafted. If the intention is to relocate back to work site in future, that can work for the green card, but it doesn't work for the H-1B. H-1B is always for a present job. So the bottom line, if you change locations personally, not your business doesn't change, your job site doesn't change, it doesn't matter where you are. For green card, for H-1B, any travel, any location outside 50 miles, if you are working from home as well, could be a problem. You might have to file an amendment. During employment-based green card process, if unable to get employment verification from previous employers, what is the best alternative? Your lawyers have to work with you. This is a highly subjective issue. We can use secondary evidence, but it isn't something that we take on normally unless we have discussed this in detail, because we have to be able to show that you're not able to get letters from the old employer, whatever the reason is. But you have to show your best efforts. So your lawyers have to work with you. There are too many details here that I can't get into. And yes, an employment-based green card can be rejected if your evidence is not supportive enough. If I have a 1 year of past experience, 35 hours, yeah, 35 hours is considered to be full-time. In the US, 35 to 40 hours is considered to be full-time. Star 5, if you have a follow-up question on this, press star 5. Okay. So case closed, benefit received by other means. What does it mean? Filed my 485 in EB3, filed another 485 in EB2, got EAD and AP cards based on the EB3 application, had spelling mistakes. Attorney opened separate service requests for both of us. USCIS cleared mine, but not my wife's. I noticed the status change for both EAD and AP filed under EB2 as case closed, benefit received by other means. So basically, they're not going to issue you two different EADs. That's not their normal procedure. So what this means is that you already have an EAD. My questions are, does the unassigned service request cause delays or stop USCIS make a decision on my 485? It should not. It should not. Is it better to get the service request closed to avoid any potential delays? I don't know the answer to that question. I think because her delay should not affect your case, I don't think it's an issue. Can you close a service request? You can call the USCIS. Your lawyers can close it. Why not? Star 5 if you have a follow-up question on this. Star 5. Okay. Pranav Kapoor, G visas. So as far as I remember, they don't do change of status to G4 within the United States. You've got to step out. And I don't think you have to go to your home country. I think you can go to any country. You have to double check this with the G4 sponsor, whether it's the World Bank, IMF, whichever the sponsor is. They can answer these questions for your friends. But the bottom line is that change of status within USA, I don't think is possible. So both husband and wife will have to go outside to get G4. And I don't think there is any restriction on a G4 EAD, just like an OPT EAD. Well, let me rephrase that. OPT EAD, the job has to be related, but G4, it can be any job. Okay, the G4 derivative can take up any job. *5, if you have a follow-up question on this, press *5. Good, we are zipping through these questions. Now this is a very interesting situation. So the gentleman is India born, the wife is born in some other country. Both filed 485s. Based upon her country of birth, he's getting cross chargeability. What happens if they withdraw her 485? I don't know the answer to that question. And I do not believe the answer exists. I believe it's something that has not been ever defined. But I have my doubts if she doesn't intend to get her green card and she just wants to live in India. Can you even get cross chargeability? I do not know for sure. I have to look at the statute, I have to look at the regulations, and I have to look at decided cases to see what the policy is and where it goes. Don't know offhand, sorry. *5 if you have a follow-up question. Next question, can students with a master's degree in progress apply for an EB2 visa? No. Your degree has to be finished if you want to take advantage of it. Okay. After they complete the degree, only after they complete the degree. What can be the possible issues? It won't be accepted. It's not allowed. Okay. Any follow-up questions? Press *5. All right. Any new questions? Press *5. Any new questions? Go ahead and press *5. Okay. I've got 1, 2. Only 2? Wow. You guys are very well informed. All right. I will 3, 4. Okay. 4, 5. All right. I've got 5 people in the queue who have pressed *5. So I'll begin with the person who logged in the earliest. This is from Kansas City, Missouri. Go ahead, Kansas City. I can hear you.
Yeah, I have a question.
I can't hear you. I can't hear you. Hello. I can't hear you.
Yeah, can you hear?
No, I can't hear you at all. Speak up a little bit. Get closer to the
Can
phone.
you hear me?
Yeah, a little bit better. Go ahead, please.
Yeah, can you hear me?
Yes, yes.
Earlier I switched employers. Earlier my company did.
You're gone, sir. I can't hear you at all.
Now.
I don't know what's going on. Are you on a speakerphone? Get off the speakerphone.
Yep. Yeah. Yep. I changed it. Yep.
Okay,
you hear me
good.
now?
Good. Yeah, speak slowly, speak clearly, and speak into the mic. Go ahead, please.
Sure. Yeah. Yeah. 3 years back, I was with a different employer. My employer filed EB2 green card.
Mm-hmm.
Yeah, buyer. But
Yeah.
due to the Persian requirements, it's changing. They are doing EB3. So my question is, can we use
Okay,
reuse
we lost your voice again in between. Hang on. Hang on. We lost your voice again. Only thing I heard was 3 years back I was with an employer. Then everything was lost. Start from there. 3 years back you were with an employer. Okay. Then what happened?
Yeah, simple. Yeah, I switched to a new employer.
Mm-hmm.
My question is, do we can we change the prior date where it was filed earlier with EB2, but currently, if a new employer files that in EB3, can we reuse
Yes.
the priority
Yes.
date from
Yes.
EB2?
Yes. The priority date doesn't care which category it was under. So EB3 priority date can be used for EB2, EB2 can be used for EB3, EB3 can be used for EB1. Priority dates can be changed across the categories. They don't care which category. Okay?
Okay, yeah.
Good luck.
And if there was,
Yeah, go ahead. Finish your question.
I think I'm good.
Okay. Please be quick, guys.
Um,
I can't hold on forever. I've got 5 more people waiting. So I am going to just be quick with your questions. Let's cover everybody. All right. Next person is from Dayton, Ohio. Ohio, go ahead, please. Ohio.
Hello, Rajiv.
Hello.
Hello, Rajiv. Can you hear me?
Yes, sir, I can.
Hey, so quick question. Interfiled 485 a few weeks ago. So, but company was sold as a successor interest last week.
Yeah, hang on. Did you
So,
connect with me? Hang on,
days.
hang on. Did you connect with me on LinkedIn also? Did you
No.
ask me the same question on LinkedIn?
No.
Okay, somebody did exactly the same question. And I told them, whenever there is a merger or acquisition, the lawyers actually, if they are good lawyers, will also involve immigration lawyers. So we plan for these things. Okay, I don't know what your company's plans are. But assuming that the companies are truly successors in interest, they have to file an I-140 amendment for you. Okay? They have to file an I-140 amendment for you. There's no way around that. Unless your 485, your I-140 is approved and 485 has been pending 180 days. In that case, you can just use AC-21 portability. Make sense?
Okay, yeah, makes sense.
Yeah. So another option you have is to wait. When was your 485 interfiled? Which date?
June 1st.
Oh, so it's just last month, huh?
Last month, yeah.
Yeah, I think you could. This is something your lawyers should work out with you. Personally, I think there is an option here to wait another 5 months and then just use AC-21 portability rather than doing successorship. Because if you do successorship, you have to file the I-140 again.
Yeah.
Okay. So if it were my case,
yeah.
I would wait until 5 more months.
Okay.
All right. Good luck.
So what if I
go ahead.
Yeah, sure. So
go ahead. Yeah, go ahead.
So one last question.
Mm-hmm.
So what if the green card is approved in the next 2
Yeah,
or 3 months?
that's the chance you
So
take.
Will it be?
That's a chance you take. Personally, I think, first of all, there is no legal requirement as to how soon you must file an I-140 amendment. Okay, there's no such legal requirement.
Okay.
So if I am entitled to AC-21 portability,
Okay.
I'm waiting for things to get portable, and you approve my green card, that's not my problem. That's the way I see it.
Okay.
Okay.
So even if my green card is approved, should my company still has to file 140 just to be
They can't.
for the future?
They can't. It's over. Green card is in hand. They can't do an I-140
okay.
anymore. Okay.
Okay, got it.
Good
Okay,
luck.
thank you, Rajiv.
Yeah, the only thing I would do is, I would ask if the green card gets approved. I would ask for a letter from the from the new employer's lawyers saying that the company qualifies as a successor in interest under immigration law.
Got it.
Okay. Good luck.
Sure. Thank you.
You're welcome. Okay. Let's go on to Ontario, Canada. Ontario, Canada, go ahead, please. Hello, Ontario. You are calling from area code 647. Okay, for some reason you're not audible. I'll come back to you. Let's go on to Illinois. Illinois, go ahead, please. 630.
Yes, Attorney Khanna, thank you for this service. Appreciate it. So
Yes, sir.
I have a question about a non-immigrant on, say, F1.
Mm-hmm.
During re-entry, let's say if the person is coming through Abu Dhabi, I think Abu Dhabi has that pre-clearance,
Yes.
or you do the immigration there instead of doing here.
Mm-hmm.
So there is some history. I don't want to get into that, but let's say if that person is denied entry there, would that person be detained there like a day or two and then sent back? Or if you say that, hey, I have a ticket, return ticket, would you just let me go back? How does it work? I mean, because we are not technically in U.S. soil, would they detain you still for a day or two
No,
and then
they won't.
put you back on the same flight? Or if you say, I already have a flight return ticket, would they just let you go back immediately?
The way I understand it is this. So you're not allowed to come to the main concourse. You stay in the waiting area where they have those little restaurants and all. You can't come out into the main airport, but you can fly back from that area. So whenever you have the next flight available, you can fly back from there. That's as far as I know. We've never been in this situation in 30 years.
So if you say you have your own return ticket,
Yep.
Instead of them putting you back on the
They are
same
not going
airline,
to.
if you
They are
say,
not
"I
going to.
already have my
Hang on. They are not going to buy a ticket back for you. They expect you to be able to get back yourself.
Yeah.
So
they're not going to detain you, right, for a day or two?
No,
or
they
something
shouldn't.
Like that?
They shouldn't. How can they detain you? You are
in
not.
In US, I think if they do.
Well, that's different.
In US, don't they detain?
That's different. You are on U.S. soil. They can detain you. But
Right.
here you are not on U.S. soil. Okay.
So if you say you have a return ticket, they should be able to let you go the same day.
That is correct. All right.
Okay. Thank you, Attorney Khanna. Appreciate it.
You're welcome, sir.
I mean, there is a.
You're very welcome, sir. Okay. Now we have 3 more questions left. Let's go to Georgia, Atlanta, Georgia. Go ahead, please.
Hello, sir. My name is Himant.
Mm-hmm.
I have 2 questions actually. I'll take first one.
Yes.
My son is studying in India,
Mm-hmm.
and there is a vacation for him in October.
Mm-hmm.
16th he will start for vacation. He
Mm-hmm.
will come back to US.
Mm-hmm.
But the problem is the visa which is there on the passport, H4 visa,
Mm-hmm.
is expiring on October 22nd.
Okay, stop.
Okay, and
Stop.
he's
Stop.
expected to
Stop.
start on 16th.
Stop.
Yeah.
As long as the visa is valid on the day he enters, it doesn't matter. They will let him come into the United States. Once he enters, you can apply for his extension.
Extension is already applied. It's in progress actually from last few months.
Yes, that should be fine. No problem.
Okay. And the problem is, another problem is, he will be returning with one of my friend's family.
Mm-hmm.
Is that should be okay, or will there be any issues?
Why should that be an issue? As long as your friend's family has authorization from you that your son can travel with them, I don't see any problem with that.
Okay, cool.
Okay.
Cool. And the second question, if I may ask,
Mm-hmm.
right? I have applied EAD for my wife. The
Mm-hmm.
same situation, right?
Mm-hmm.
EAD is approved,
Mm-hmm.
but it is approved until October.
Yeah.
Okay. Can she start working? Because my H4 is in progress. Can she start working? If yes, can I apply the renewal with my H1 approval, which is already approved until 2020?
Yeah, she can't start working if she doesn't have approval on the date she starts working. And once you apply, you can apply for her EAD extension and H4 extension. Okay. But she cannot start working until she gets the approval, because she can only work as long as she has an I-94 covering the period she works. Technically, there's a 180 day plus another 300 some days of grace, but that grace is only available to the life of your I-94. If the I-94 expires in 3 days, even though technically you have availability of grace period, it doesn't apply if your I-94 ends.
Okay.
So she cannot start working.
I heard there is a 6 months.
Yeah, that doesn't apply if your I-94. Yeah, if your I-94 is expiring tomorrow, there is no 6 months.
Okay. Got it.
Good luck.
Thank you. Thank you so much.
You're welcome. Okay, second last question. Then I'll go back to Ontario, see if they can hear me. So this one is from Pennsylvania. Pennsylvania, go ahead. I can hear you.
Hello. Good afternoon, sir.
Good afternoon.
My wife's birth wasn't registered at the time of her birth. Based on the documents and the affidavits and the school evidence, the municipal corporation and the birth and death certificate committee issued her original birth certificate, but the registration and the issue date is current as of 2019. So during her 485 filing, would that be an issue because the registration is 3 years older?
Yeah, they are not going to accept that as evidence of birth, but they will accept secondary evidence such as school leaving certificates, non-availability letter from the municipal corporation saying there was no previous registration, and also affidavits from people if she was born in a hospital, some evidence from the hospital when she was born. These are some of the things they would accept cumulatively. So I also give them my Aadhaar card. I say, look at my Aadhaar card. That's national identity. So I do that. Let's see. Go ahead.
Yeah, no. So we have the school leaving affidavits, Aadhaar card, and all the past evidence documents with the right date. Only the birth certificate wasn't available. And
that late registered birth certificate is zero value. Okay. You would be hang on. You need a non-availability letter from the municipal corporation saying before we registered this birth there was no previous entry on this birth date. You will need that. That's required.
And we did check for that, sir, and they said since we are issuing you the birth certificate and it has a language that this birth was never registered before, they're not willing to give us a
you can argue that, but if government should accept it, that's the reasonable thing to do. But since when has USCIS been reasonable? So they should accept it. Hopefully they will. If they don't, what you can do is you can show them a copy, show the municipal corporation a copy of the RFE and say, look, this is what the US government is asking for. Can you give us a letter?
Okay. And then as secondary, we can use the school leaving and the Aadhaar card.
Oh, yeah. Absolutely. I think you'll be okay. Yeah, I think you'll be okay. Okay?
All right. Thank you, sir.
You're welcome. Okay, so last question is from, one second, from Ontario. Canada, can you hear me?
Hello?
Yes, go ahead.
Hello?
Yeah, go ahead. I can hear you.
I'm sorry. I'm sorry for the inconvenience before. And my question is, I'm a Canadian citizen and I'm holding a Canadian passport. So as per, I want to come to US for the work visa, but as I go through the process of NAFTA program, I'm an account executive. So I have a work experience for 5 to 6 years in Canada.
One second. What are your degrees, ma'am?
I am bachelor's in commerce, and as I came to here in Canada, I studied finance program.
Okay. And you said you have 5 years of experience, 5 to 6 years of experience?
Yeah, yes.
Doing what? What did you do for 5-6 years, ma'am?
I work as an account executive as a software marketing.
It's going to be a stretch, but you might be able to qualify as a business consultant. It's one of the most difficult categories to qualify under, but that category only requires 5 years of experience. It doesn't require a degree. Okay. So
how, what would you suggest, how I can process my work visa?
You need to get a job offer as not a job offer, but a consulting gig in the United States where an employer describes your job fully and explains that they are going to hire you as a consultant to do. So consultation basically means you're helping them with some processes. So you can then try to get in as a business consultant. Okay. I can't tell you any more than that, but you can hang on, ma'am. hang on.
Yeah, okay.
Just research
Yeah.
business consultant category for NAFTA visas, for TN visas. It's not really NAFTA anymore, but yeah, TN visas.
Okay. Yeah.
So research that and you'll have more information on that. I think that's the category for you. Go ahead.
Okay, can I have one more question, please?
Sure.
Can I ask you one more question?
Go ahead.
And my second question is, if somehow I am able to arrange an employer, but that employer is giving me a different kind of job that doesn't belong to my work experience or my studies, will it be able to help me to get work visa in States?
Almost certainly not.
Certainly not.
Almost certainly, because I don't know for 100%.
Okay.
But when the job is unrelated to your experience, that doesn't get you a visa. Okay?
Okay. Thank you so much.
You're welcome.
Thank you so much for your help.
Good luck. Okay. Somebody else just raised their hand. 1 second. So this is Atlanta, Georgia. Go ahead. How can I help you?
Sir, I asked already the question, just a quick thing. For the EAD renewal, can I apply for EAD renewal with my H1 approval?
So is she in
Is
she in the United States? Is your wife here?
Yes, she is in the United States.
Yeah, why can't you apply for an EAD renewal? When is the EAD expiring?
Because H4 is in progress.
Yeah, you can still.
EAD is in October 20.
Yeah, you can still apply for an EAD renewal. I don't know how far ahead of time you can. I think it's 4 months or 6 months, whatever that time is. Even though the H4 is still being renewed, you can file the EAD. No problem.
Okay.
All right.
For the renewal, right?
Yes, sir. Good
Thank
luck.
you,
All right. Bye-bye. All right, folks. It looks like we are done for the day. As always, it is a pleasure and a delight to hear from you all. I'll see you again in 2 more weeks. Thank you for being here. Bye-bye.